The H1B guy here, and today the H1B guy breaks down Senate Bill 3770, H1B and L1 Visa Reform Act of 2020. But before we get started, I'd like to ask you, if you haven't already, to please subscribe to the H1B Guy channel here on YouTube. It helps me to continue to produce more content like this for you. And a special thanks to YouTube subscriber at Vishnu2AVV for asking me to cover S3770. So Senate Bill S3770, titled H1B and L1 Visa Reform Act of 2020, was introduced on the Senate floor on May 19th of 2020 by Senator Chuck Grassley and co-sponsored by Senator Dick Durbin, Senator Richard Blumenthal, Senator Sherrod Brown, and Senator Bernie Sanders. S3770 will attempt to, quote, amend the Immigration and Nationality Act to reform and reduce fraud and abuse in certain visa programs for aliens working temporarily in the United States and for other purposes, end quote. We're going to cover the sections most relevant to the H-1B visa here today, and we're going to talk about the recommended amendments and give an opinion in our breakdown sort of on each one and its impact going forward. So we're going to start with Section 101, Modification of Application Requirements. And this is basically where the minimum prevailing wage for H-1Bs is going to be determined by the highest of the following three. So a prevailing wage for the local area. Second would be the median for workers in the local area performing a similar occupational classification. And then last, the median wage for skill level 2 from the most recent Occupational Employment Statistics Survey. The takeaway here is that preferences are going to be given to those who are paid the highest wages. This will eliminate the, quote, cheap labor argument for anti-H-1Bers that we see out there, as you can see preference and priorities given to the higher earners. The internet posting requirement will mean that jobs must be posted on an internet website for 30 calendar days and include the minimum requirements. I can tell you, having managed perm labor postings in the past, I can foresee this being quite the task to manage. I'm not saying that this is something that shouldn't be done, but I'm very interested to see how it would be managed. Displacement of non-U.S. workers, meaning that you cannot displace a U.S. worker with one or more H-1Bs, and also can't displace a U.S. worker 180 days before or after an H-1B is hired. Here's a big one, and that's the waiver requirement. So this is entirely new language that we see. And it says, quote, the employer will not place, outsource, lease, or otherwise contract for the services of placement H-1B immigrants with another employer, regardless of physical location where such services will be performed, unless the employer of the alien has been granted a waiver under paragraph. So we've been talking about and insinuating the death of the third-party consultant here on this channel for several weeks. Here we see it in black and white language. If you want to place an H-1B at a third-party end client site, if this becomes law, it will require a waiver. So let's think about that. How long could that approval process take? Who's responsible for approving the waiver? USCIS? We'll answer those questions at the end of the breakdown, so please stay tuned. But this language will all but eliminate the subcontractor firms that hold less than 50 H-1B visas on their W-2. Requiring a waiver for every third-party end client placement is going to require a lot of approvals. Moving on to Section 102, new application requirements. This covers advertising and what advertising can and cannot state. Advertising cannot state the position is only for an H-1B, that H-1Bs are going to receive priority or preference, that the employer is only recruiting H-1Bs to fill the position. It also covers the 50-50 rule and combines H-1s and L-1s for a total population. And it also states if the employer employs one or more H-1Bs, they must submit a W-2 wage and tax statement form to IRS in reference to the H-1B. So here we see the continuation of the protection of U.S. workers, this time in the form of prohibiting the recruitment of only an H-1B visa to fill the opening. The other point of interest is the mention of the 50-50 rule, and now that it would combine the total non-immigrant population, not just accounting for H-1Bs. Section 103, application review requirements. So this is where the Secretary of Labor will review an application and identify any fraud or misrepresentation in order to initiate an investigation. And again, here we see more power to the Department of Labor to enact investigations for really any justifiable reason. Section 104, H-1B visa allocation. And this is where it refers to aliens who are subject to numerical limitations will be issued visas in the following order. All right, and it gives a long list, but I'm just going to cover the top ones, which is you are physically present in the U.S. and you've earned an advanced degree in STEM from a U.S.-based institution of higher learning. The next one is for the employer paying a median wage for skill level 4 for occupational classification. The third is you're outside of the U.S., but you possess a U.S. advanced degree in another program from an institution of higher learning. So that means you have a U.S. master's, but it's not in the STEM field. And then fourth, we see coming in as the median wage for the skill level occupation 3. And for those of you who aren't aware, there are skill levels 1 through 5 and 6 that cover sort of the junior to senior level and managerial level. If we go a little further down, the employers must meet the following criteria, which is a verify number, ID number, or if they use an agent, that commercial enterprise is in good standing with E-Verify. The employer must also verify that they've not violated any immigration laws in the last 5 years, and that the 3 previous fiscal years possess a 90% approval on their petitions filed, and that the petitions filed also include approved LCAs for 90% of the employees. Now here at the very bottom of this section, we see STEM defined as computer and information sciences and support services, engineering, biological and biomedical sciences, mathematics and statistics, and physical sciences. So spelled out in black and white, the priority order in which H-1B visas will be issued is now weighted for anyone currently in the U.S. with an advanced STEM degree, for high earners at a skill level of 4 or higher. Other priorities will be given to U.S. advanced degrees or bachelor's degrees and skill level. So it's really interesting, and I think the question that needs to be asked here is this the beginning of the weighted value merit-based point system that we've been discussing here on this channel over the past week? You can go back to the video posted last Thursday where we researched merit-based immigration systems to look into that a little further, as well as the video from yesterday where we talked about our friend who left the U.S. for the merit-based immigration system in Australia. Section 106, specialty occupation to require an actual degree. So this is basically saying that if you want to enter in a specialty occupation high school category, you must possess a bachelor's degree or higher in the specific specialty occupation. And then it kind of covers what else is required, either a state license to practice in the occupation, or a U.S. degree or a foreign degree equivalent to a U.S. degree. So what's interesting here is clarity provided around the degree type and it being associated with the specialty occupation. We've seen this interpretation from USCIS for the past few years, specifically in the computer systems analyst category. Section 107, the labor condition application fee, says that employers would be required to pay a reasonable application processing fee. and that, quote, all fees collected under this paragraph shall be deposited as offsetting receipts within the general fund of the Treasury in a separate account, which shall be known as the H-1B Administration, Oversight, Investigation, and Enforcement Account, and shall remain available until expended. The Secretary of Treasury shall refund amounts in such account to the Secretary of Labor for salaries and related expenses associated with the administration, oversight, investigation, and enforcement of the H-1B non-immigrant visa program. So, what's considered a reasonable fee? The funding provided by the LCA will account for the increased costs of the administration, oversight, investigation, and enforcement. More on that in a little bit. Section 109, limitation of extension of H-1B petition. Basically, it goes into the period of authorization may not exceed 3 years, and it may be authorized for 3 years if the total period does not exceed 6 years, except under extension of AC 21. I will tell you, I read this multiple times, and I'm not exactly sure what changed within this amendment, but it appears to be fairly straightforward based on current interpretation. Section 111, general modifications of procedures for investigation and disposition. So surveying the degree, compliance audits if employing an H1. This is basically where we're going to get into the DOL will conduct audits of 1% or more employers and employee H1Bs during the calendar year. Audits for employers with less than 100 employees and 15% H1B population. We'll make these findings public, and then there will be a hotline for complaints. So this just continues the DOL path and allows them to conduct audits, specifically with at least 1% or more of organizations that employ an H-1B, as well as if you employ 15 or more H-1Bs and have less than 100 employees working for your organization, you're guaranteed to be audited. So what does this tell us? Again, it is just the continuation and the tightening of the grip around the third-party consultants working under H-1B at in-client sites. Section 112, investigation, working conditions, and penalties. So a failure to meet a condition, the fine would be increased to $5,000. Failure for lost wages and benefits, that fine's increased to $25,000. And a fine for a displacement of a U.S. worker, a $150,000 fine. No surprise here, but major increases that will be levied against violators. Very interesting to see significant increases in the fines here. Section 113, waiver requirements. So if you remember going back to the top, we talked about the waiver that would be required. So the Secretary of the Department of Labor determines that it does not displace a U.S. worker and will not displace a U.S. worker 180 days prior, before, and after the H-1B is hired. That principally controlled and supervised by the petitioning employer. That's a big one. And that this is not an arraignment for hire, or what we deem contract to hire, meaning they're not bringing on the H1 under a contract arrangement to then potentially convert them, and that the DOL will grant or deny any waiver requested within 7 days of receiving the request. So in order to be approved, you do not displace a U.S. worker, you clearly show right of control, you've not considered or considering this as a contract to hire, and that the DOL is going to respond back within 7 days of the request. The right of control has really been one of the big sticking points we've seen from USCIS in cases selected for RFE over the last 3 to 4 years, requesting end clients, vendors, and employers to provide supporting evidence that documents and designates the right of control. Remember the questions that we asked earlier about how would this waiver application process work? Well, we see the DOL saying that within 7 days of receiving the request, they will respond. Section 115, information sharing. and it says that USCIS will provide the DOL, and it indicates if an employer is not complying with the visa program requirements for H-1Bs. What's interesting about this one is that it may be redundant now, considering there was a memorandum of agreement that was issued by USCIS and the DOL right after President Trump's executive order from 2 weeks ago. Section 121, posting available positions through the Department of Labor. The DOL will create a searchable website for posting positions. I'm sure that will go really well. The government creating a website from scratch that will be highly searchable. But the one saving grace is that there is at least language that will allow for the DOL to use a private firm to create the site. Section 112, transparency and report on the wage system. So this is where an employee can request the original petition if they're leaving an employer from a former employer. And it also talks about the Comptroller General of the U.S. and what they're required to return. So this section, what's interesting is that it actually gives the employee some power and the ability to request their original petitions. Section 123, requirements for information for H1 and L1 non-immigrants. So these are for visas that are issued outside of the U.S. They will provide a brochure outlining the employer's obligation, the federal agency's contact information, and a copy of the petition. Like a brochure and some phone numbers are going to solve their problems once they get here in the U.S. But it's interesting to see that they would be required to provide a copy of the petition. I don't think that that's something that they've done before, so very interesting. And then the last section, Section 124, additional Department of Labor employees. And this says the DOL can hire up to 200 additional employees to administer, oversee, investigate, and enforce. And here it is, more government jobs. Remember those LCA fees that we talked about being collected earlier and the Secretary of Treasury? Well, they will be the primary source of revenue generated to create the 200 additional DOL jobs. So next week, we'll cover the second half of S3770 that's addressing the L1 visa fraud and abuse protections. I wanted to break these down into two different parts. But as it stands, and as I look through 3770, I think there are some positive reforms that are being brought to the table here. The questions become how would they be implemented and at what cost? These are really unanswered right now, but I think that we need to see some clarity around, the implementation and the cost. S3770 will definitely add scrutiny towards the third-party in-client placements, as we've talked about the death of a third-party consultant. Is that a good or a bad thing? Well, it's definitely highly debated. It's a very hot topic. And I guess that really just depends on where you stand in the staff augmentation food chain. Because I can tell you that there are a lot of jobs that go unfilled because they cannot find the talent. And that talent I'm referring to are the highly skilled specialty occupation employees, generally here on H-1B visas. So for the full post, check out the H1BGuy.com. If you want to read all about the H1B Guy breaking down S3770. Tomorrow, we're going to come at you with another round of the H1B Guy Unfiltered. This time, it's the H1B Guy Unfiltered Round 2. I want to thank you if you've made it this far for watching my video. If you can please give this video a like, and again, subscribe to the H1B Guy here on YouTube and click the bell for notifications. Just really appreciate your support. The H1B Guy, your global source for all things H1B.